Hey everybody, and Happy New Year! It's your favorite neighborhood lawyer with Trademark Law, Markwell Cade, back with another resource for you. Today, we're going to talk about 5 frequently asked trademark questions and the answers you need to know. These 5 questions are questions that I get from clients all the time when they're trying to register their trademarks. I hope in the future, this video will provide a resource for them, for you, and for anyone else who has a similar question. One of the most common questions I get is, do I actually need to be selling a good or service in order to register my trademark? The answer is yes. If you're an aspiring trademark owner and you don't actually sell a good or a service in conjunction with the trademark you've created, you've just created a clever slogan or a clever brand name. In order to receive trademark protection, you need to actually be selling a meaningful number of goods or services in order to receive the protection. In other words, your good or service must be associated with that mark. Otherwise, you've just come up with something clever. And I have a number of clients that are clever and come up with a lot of creative things. But that doesn't mean you can trademark them. You need to be using it in the conjunction of a sale with that good or service. The next most frequently common question that's asked of me usually follows that first question. Do I need to be selling my goods or services in the entire country to get trademark protection? Yes. To obtain federal trademark protections, you need to be selling your good or service across state lines, and the number of sales must be bona fide. Now, a bona fide number of sales is just a fancy legal term, or fancy non-legal term, if you will, that really just means a fact-dependent situation where sales and your mark are used in conjunction with one another. It could be 1 sale, it could be 3 sales, it could be 300 sales, or 3 million sales, or 3 billion sales. You get the point. But you must be selling your good or service in conjunction with your mark across state lines. Now, in this day and age, usually that digitally means the internet. The internet is a great way to sell across state lines, and using your mark in conjunction with internet sales is a great way to get that federal trademark protection and get those bona fide sales that you need. Now, that naturally segues me into my third most commonly asked question. How many sales are bona fide? Or how many sales do I need to meet the in-commerce requirement set by the USPTO? Well, unfortunately, there isn't a set clear guideline for this. As I mentioned in my previous question, this is a fact-dependent situation. It could be 3 sales, 300 sales, 3 million, 3 billion, you get it. But you must demonstrate that you've made sales in conjunction with the use of your mark. The more sales, the better. But this doesn't mean that only selling to a few people will prevent you from registering a trademark. One of the next questions that I get a lot is, do I need to register my trademark before I start selling my good or my service? No. However, it may be prudent to do so. You don't have to tie your shoes, but do you want to trip and fall everywhere? It's the same concept. You want to buckle up business and you want to register to protect your trademark as soon as possible. Conducting business without the protection of a trademark, or without the protection of a registered trademark rather, may render you vulnerable to a third party using and preemptively registering the trademark before you get a chance to. In some countries, this is detrimental. They follow a first to file system, which means that if someone beats you to the trademark office and files that trademark first, they own the mark. It's theirs now, and there's nothing you can do about it. This is why I advise my clients to register as soon as possible. While you need to have sales in conjunction with the mark, in conjunction with the good or service, it's important to remember that that bona fide sales requirement is not something that's defined. 1 or 2 sales is enough. Don't wait until the mark becomes big and then go, oh, I have the money to hire a lawyer. Let me protect this. Protect it as soon as possible. So while it's not required to register a trademark before you start selling a good or service, it's a good thing to do, just like tying your shoes. The 5th question that I get that's very common, usually comes up when people started filling out their trademark application on their own. Maybe they thought they didn't need legal guidance or they don't have the ability to hire a lawyer, and they come across legal jargon and legal terms that they don't understand. This question, what is a specimen and when do I need one? A specimen is just a fancy way of saying an illustration of how you're actually using your mark in commerce. This could be a picture of a label, packaging material, a tag, a flyer, even if you're selling a service, a link if you're selling a good. Simply put, a specimen is proof that you're actually using your mark. If you don't have this specimen, your trademark application will be denied. So your specimen is perhaps one of the most important parts of your trademark application. It's good to understand what it is. You'll need one before you finish filing. You can fill out your trademark application without the specimen, but at some point, the trademark office will ask you for it, and you will have to provide it. That's all, folks. Thank you so much for joining us today. This has been 5 frequently asked questions in trademark law. My name is Markwell Cade with Trademark Law, your favorite neighborhood lawyers. Protect your brand, grow your business. Stay frosty, my friends. We'll see you tomorrow.